conduct has to result in a forcible tort. And the forcible tort has to result directly and immediately from your conduct. So you always have a situation where the actor is engaged in certain conduct, certain force, and they're intending a tort with that conduct. An unintended tort happens, and it happens directly and immediately from the force used for the intended tort. So that's 4 requirements: intended forcible tort, resulting forcible tort, direct and immediate. But you have to understand what direct and immediate means. It means the force used for the intended tort directly and immediately resulted in the unintended tort. The courts will generally, as a general rule, transfer intent under those situations. Now, where do students mess up on that? Either by forgetting one of the requirements, forgetting to tell me what the requirements are, or they forget the corollary rule you do not want to forget. There is no intended tort if the intended tort was privileged. If it was privileged, the courts say, that doesn't work then. You don't have an intended tort for transfer to tort purposes. So I do intend an entry on land of another. I intend to bang my way into your house by jamming the door open. It hits you in the eye. You sue me for battery. I didn't know it was going to batter you. My purpose was not to touch you. I didn't know my conduct would result in you being touched. I didn't even know you were behind the door. But I did intend a tort. I intended trespass. The court will transfer the intent from the intended trespass to the resulting battery if it happened directly and immediately from my conduct, which here it did. I jammed the door open and it hit you. So now you've got transferred intent. You've always got to stop at that point and say, unless the intended tort of trespass was in this case privileged. If it was privileged, there is no transferred intent. Which means on an exam you always watch out for in transferred intent whether the intended tort you're going to argue was privileged. If it was privileged, no transferred intent. Generally in an essay exam, it's going to be arguable whether it was privileged. What do you do then? Then you say, as shown above, it was arguable whether the trespass here was privileged. If it was privileged, no transferred intent. I concluded above it was privileged. And therefore there's no transfer intent, but a court might disagree. It was arguable. A court might disagree, and if they did, if they found out that it was not privileged, or if they held it was not privileged, then transfer intent would work here. To say all that shortly, where time is of the essence in answering an exam, you just say, as shown above, it was arguable whether privileged. If it was privileged, no transferred intent. If it was not, transferred intent. And move on. You've always got to move on, even though it seems clear about something, because the court might disagree with you. So in analyzing something, it's no different than in real life. If I ask an attorney working for me to analyze something, I want to know what they're going to say about each of the elements. I don't want them to say, I didn't say anything about those 3 elements because it was obvious. You still have to prove them at trial. If it's obvious, it means it's easy to prove at trial, but you still deal with it. So deal with each and every element of the tort. I think that's about exhausts how you could miss points on intent. You got to throw the word forcible in there. You can take points off if you don't say transfer intent, you got an intended forcible tort. Yes. The fact you got an intended tort does not start a transferred intent analysis. There are many intentional torts: deceit, fraud, nuisance, all sorts of things. Intentional infliction of emotional distress. Transfer intent doesn't work for any of those. It works for those 5 or 6 traditional forcible torts: assault, battery, false imprisonment, trespass to land, trespass to chattel, or conversion. I think that's it on transferred intent or on intent. No, that's not it. There's a couple other things you have to remember. Well, you got an infant in a fact pattern. Can an infant have intent? The answer is yes, if you can prove it. You know, was it their purpose to bite you? If it was, it's intentional. There are cases that just say at a certain age you're not capable of this. What they're really saying is a matter of policy, they're not going to be liable. If a little 1-year-old is smiling at you and then moves its head to bite you on the arm, that's clearly an intentional touching. It's the courts, for policy reasons, haven't found 1 or 2 or 3-year-olds generally liable for any torts. But beyond that, 4-year-olds shooting arrows at people, if you can prove intent, their age is irrelevant. We saw that in Garrett v. Daly. So age is not going to affect intent. Also, mental disability is not going to affect intent. Person completely mentally disabled, they're delusional. If you can prove they intended the touching or they intended the entry, the court will treat them like anybody else, again, for policy reasons. So it's irrelevant that they're mentally disabled. If they're so mentally disabled that you can't prove intent, well, then you're just stuck with facts where you can't prove intent. But their mental disability is irrelevant. Mistake of fact. This is where you have these compelling situations where lay people would say, clearly he didn't intend to do it, he didn't know. It's the shooting the wolf, hunting the wolf, seeing the wolf, shooting at the wolf. Turns out it was a dog. You're a dog lover, you never would have shot a dog. So the natural reaction is, I did not intend to shoot that dog. The court's response to that is, it was your purpose to hit that chattel. Your mistake of fact about whether it was a dog or a wolf is irrelevant. Mistake of fact does not remove intent. In a trespass situation, you intend only to go in your house. You've had everybody on the street saying, of course that's your house. You walk in, it turns out it's not your house. You never intended to go in the other person's house. The court would say, yes, you did. It was your purpose to go where you went. So it was an entry, and you intended that particular entry. Conversion. It's not your intent to deliver the necklace to anyone other than the post office. The post office shows up and the uniform shows our identification as being the post office. The rest of it, they're accepting delivery. It turns out it's a fraud. You say, I never intended to give it to some robber or thief. I only intended the post office. It was given to somebody else, therefore I didn't intend that loss of the necklace. The answer is, you intended the interference. You intended to place it in the hands you placed it in. That was your purpose, to put it in those hands. Therefore, and putting it in those hands caused an interference. Therefore, the interference was intentional. What you're really saying is you made a big mistake of fact. It does not remove intent. Now, where do students screw up on mistake of fact? They say there's a mistake of fact here and that proves intent. That's wrong. Mistake of fact doesn't prove intent. We've already seen the limited ways you have to use to prove intent. If you can prove intent, mistake of fact doesn't remove it. So don't say it incorrectly. You're being judged on how correctly you can state the law. That should do it on that. Okay, battery. What is there to know about battery that we don't already know? It's a simple tort. The fact that it's simple doesn't mean I don't expect you to hit every element. One of the dangers students get into this mental pattern of assuming I know what I'm doing and you know what you're doing, so you don't put it down on paper. And then you come up to me later and say, I had it all in my head, and I say, but it didn't get onto paper. So with battery, you've got to show me, you know, how many elements, how many things does a plaintiff have to prove to win a case for battery? Which means you have to have a definition. That's the purpose of the definitions. It tells you what you have to prove. I think the simplest and most efficient definition for any of these torts is you say conduct intended to cause and causing, in this case, a harmful or offensive touching without consent, and then you add on without privilege. Plaintiff doesn't have to prove no privilege. They have to prove conduct intending to cause and causing a harmful offensive touching without consent. Then they can sit down. Then they've won the case unless the defendant stands up and